a finding against 2 members of parliament. The commissioners read the report and did not think that the facts as appeared in the report justified the conclusion. And we issued a separate statement indicating our disagreement. And it's just that we seem to have very short memories. But that did happen. And of course, some people were not pleased that the commissioners did not agree with the director of investigation. Well, so far, the reports that have been submitted to us, that we have passed on to Parliament, we have not seen anything for us to say that they should not go to Parliament.
With due respect, Chairman, there's one in which the Director of Investigation submitted a final investigation report on February the 19th, 2023. This report was not tabled in the Houses of Parliament. I mean, this is coming from a report you sent to us.
May the director be allowed to answer that last.
Yes, I suspect that matter has to do with a matter that is in court.
We're
So
talking
if
about
we're,
reports.
if we're going to open that gate, then let us open it.
Chairman,
I
we're talking
wouldn't, I
about
wouldn't
reports.
wish, I wouldn't wish that that gate be open, but I think it's in the generality of reports,
Yeah.
and this has to do with procedure. It doesn't really have to do with the specifics of a report,
And
but
we,
rather
we,
it is
we,
procedural.
we understand the sub
and
judice
that's
rules.
admissible.
The director can answer.
Yeah.
He can answer.
Thank you very much, Chairman and members. Good morning. The provision that governs the tabling of reports in Parliament, or the treatment of reports generally, is Section 54 of the Integrity Commission Act. Uh, Only certain reports are required under that section to be sent to Parliament for tabling. So, for example, if during the course of the investigation, the Director of Investigation is of the view that there is insufficient evidence to continue the investigation, what happens is that the director will terminate the investigation and issue findings to the commission. That report is not tabled. The other category of investigation reports would be investigation reports that contain findings which are considered to be a breach of code or any law or an act of corruption. That category of report, having been sent to the commission, would thereafter be tabled. If it's only a breach of code, it would go directly to the commissioners, then to Parliament. If there's a breach of law and there is a recommendation to be sent to the Director of Corruption Prosecution, the report is referred on to the Director of Corruption Prosecution together with the file, and having completed her ruling, that would be sent back to the commission, and it is then sent to Parliament for tabling.
One,
I am not sure if I should comment on the
no, no, no.
February report,
No,
but
not at
that
all.
is the general.
No, because the follow-up question, Chairman, is simple. You do a lot of investigations and you do reports on these investigations. What proportion of these investigations would you say you table reports on to the executive director or the commissioners?
If you give me a second, Chairman. In the annual report itself, there is statistics on all the matters that have been referred to me during the course of my tenure at the Commission. So there are two categories of matters that may be
Hi, my name is Professor David Costa, and I'm here today to introduce the University of Cambridge.
public, etc. And then there are referrals that come either from the Director of Information and Complaints having to do with statutory declarations, financial investigations, or the Commission for further necessary action. So far, in terms of complaints, between 2018 and 2024, there were 246 such matters. You can find that at page 58 of the annual report for the year 2023-2024, financial year 23-24. Of that number, over the period, only 155 of those matters were pursued. 12 of those matters were referred to the Director of Corruption Prosecution. 13 were referred internally, and by this I mean it could well be that, for example, there's a complaint on a contract. If the contract is still ongoing, then we would refer it on to a monitoring unit to review the execution of the contract and to provide findings. That does not necessarily result in an investigation report. And then there are matters that may be referred externally, for example, to our competent authorities or other entities, matters that are not in our remit, for example. And then there are matters that are closed on preliminary inquiry. Now, Section 47 of the Act requires the Director of Investigation, when a matter is referred, to look at the matter to see whether the matter is one that is frivolous and vexatious, whether another entity is dealing with it, or whether it is within the remit of the Commission at all. During that process, information could be requested from external entities. The complainant could be spoken to. Several investigative actions or preliminary investigative actions would be conducted. If at the end of the day, there is insufficient evidence to justify the conduct of a full investigation, then the matter is closed on preliminary inquiry. 82 such matters were closed during the period I referred to earlier, 2018 to 2024. You will also see at page 50 of the report the number of matters completed over the 5 years period, or the 2018 to 2024, a total of 161 were tabled in Parliament. And you'll see the statistics there. Except I'll not go further into the statistics, except to say that of all the referrals made to the Director of Investigation for this period, we have completed 96% of those matters to date.
So really and truly, Chairman, the question is the Director of Investigation completely independent as to what reports he continues, terminates, or do you report to the commissioners and the commissioners can direct you that it should stop or it should continue?
The Director of Investigation is subject to the general and specific directions of the Commission. In terms of the governance structure of the organization, under which we operate, the division is supervised by a committee, the Investigation and Corruption Prosecution Committee, and each month there's a report made to the committee, the matters that are being investigated or inquired into, the completion of matters, etc. The operations generally of the Commission. I make reports to the committee on those matters.
Sorry, Chairman, while the deliberations were happening, I sought the legal advice in relation to the position of the Oversight Committee vis-a-vis the Commission. And I was referred to Section 5.4 A and B of the Integrity Commissions Act of 2017, which said the commission shall, A, subject to section 34(3) and 36(4), be ultimately responsible and accountable to Parliament for all matters relating to the functions of the commissioner, and monitor and report to Parliament on the operations and effectiveness of the provisions of this Act. So that's very clear, I believe, in terms of the reporting procedures in relation to accountability.
Morning and welcome to the Commission and the team. I have three questions. Last year, sometime I'd asked the members of the Commission whether persons who are subject to an investigation for illicit enrichment, whether they are so notified. And you answered in the affirmative. I'm going further, and I'd like the Commission, through this committee, to provide a sample copy of the letter which is sent to an individual who is the subject of an investigation for illicit enrichment. I would like to satisfy myself as a member of this commission that there is clarity and there is no ambiguity in the correspondence from the Integrity Commission to individuals who are the subject of investigations for illicit enrichment. That's my first question. My second question, which may be directed to the Director of Investigations, I'd like to know what percentage of investigations undertaken by the Integrity Commission are referred to third-party bodies, units, for further investigation, and what factors are used to determine those referrals to those third-party bodies. And my final question relates to the practice of the Integrity Commission, which discontinued the routine quarterly publication of contracts, which are awarded by the government of Jamaica to various bodies, and did so under the basis of an interpretation of the Integrity Commission Act. And I believe it's section 53.3, which you have interpreted to preclude you from doing that publication. I'd like to know whether the Integrity Commission is open to seeking an independent legal opinion on that particular provision, and whether you would do so from the Attorney General's chambers. I personally don't support your interpretation, and I know for sure it was not the intention of the crafters of that particular clause for it to preclude something which is in the general interest of transparency and openness. So those are my three questions, Chairman.
Just before the chairman responds, in the context of that first question with regards to illicit enrichment and a better understanding of what it is, I referenced the report of 2324 and in fact the message from the chairman, and I read that he says on illicit enrichment, the act provides that any person may be orally or in writing make a complaint, give information, or notify the Integrity Commission about a matter which involves or may involve an act of corruption or non-compliance with the act. He went on to elucidate on the matter by saying, when a person approaches the Commission in this way, the Director of Information and Complaint is compelled to record the complaint or information and submit it to the appropriate director of the Commission for action. The Act also provides that the annual report must contain a general description of the matters that were referred to the Commission and a general description of the matters being investigated by the Commission. The Commission has no control over the complaints and allegations it receives. It must, however, investigate them and make a note of the fact of the receipt and the investigation in the annual report. This is what the legislation passed by Parliament requires. The police received numerous complaints, he made a further point, and allegations of various crimes that, when investigated, are found to be without merit. So does the Integrity Commission, which has no control over speculations, rumors, or mischief making in the society. And that was his line on illicit enrichment. So I just, further to your question, so essentially what we're saying then is it that the illicit enrichment is these complaints which you get? No, but it's important, I think, because in giving clarity to the whole process, and this is from the chairman, it's very important for us to take note of this. Yes.
If you allow me, Chairman, what you said is valid, but it's not what I'm asking, and I don't want it to be confused. We accept that any individual can make a complaint. I'm not going there. I am going where you initiate an investigation. I want to know the text of the correspondence sent to the individual, because I need to satisfy myself that the individual is clear about what he or she is being investigated for. That's where I am going, not whether Tom, Dick, or Harry send a complaint and whether it rises to the level of whether it meets the evidentiary bar to be investigated. It is when you commence and what you say to the individual once you commence.
Oh, I hear you, and I hear you well. But I read this piece because it gives a background to what could constitute the investigation, so that the public understands clearly that the investigation may not be that the persons are guilty of anything. Unfortunately, that's the sense that the public gets once it is out there. And I wanted that point to be made clear. And I think the chairman was very clear on it in his report, and it bears repetition. But proceed with the answer.
Thank you.
Thank you very much, Chairman. On the first point, the first question, whether a person who is being investigated for illicit enrichment is notified by the commission, and you want to know the exact text of the notification. Uh, yes. Now, when a matter is referred on to the Director of Investigation for investigation, for example, illicit enrichment, it is the practice, as I recall it, of the Director of Information and Complaints that he advises the declarant that the matter is being referred. My recollection, and you may correct me if I'm wrong, the letter does not say that you are being investigated for illicit enrichment. And he says that I am correct. Now, when the matter comes to the Director of Investigation, that matter has to be assessed. There has to be investigation into the matter before the declarant can be advised that they are being investigated for illicit enrichment. Because the Director of Information and Complaints doesn't necessarily go in depth with the matter. For me to, at the start, indicate to the person that you are being investigated for illicit enrichment might be a little bit premature because of what the legislation requires, Section 14.5 of the Corruption Prevention Act. So there is preliminary investigation or in-depth investigation. Now, I would also send a letter to the person once I receive the matter to say that this matter has been referred to me. I will not necessarily say that you are being investigated for illicit enrichment for the same reason I mentioned earlier at that early stage. Now, once there is sufficient evidence that this person owns assets disproportionate to their lawful earnings, or there is some evidence of it, some indication, a notice is sent to the person. At the head of the notice, I don't have it in front of me now, there it states what section of what legislation the notice is being sent under, and then it would be Section 48 and Section 14.5. And the words illicit enrichment are also in the header of the notice. Now, if I may read for you, um, maybe two paragraphs from the notice itself. It says, take notice that the Integrity Commission is investigating the statutory declaration submitted by you for the year so and so to determine, among other things, whether there are reasonable grounds to suspect that you have contravened Section 14.5, which is the section that deals with illicit enrichment of the Corruption Prevention Act, and if there are any other legislation that we're looking at the person under, then we'll also state that in this case, if there was Section 43.2 of the Integrity Commission Act or any other enactment, and whether recommendations ought to be made hereinafter the investigation. The second paragraph is important. Take further notice that the Commission, from the proceeds of its investigations so far, has determined that you own assets disproportionate to your lawful earnings insofar as have been declared by you. Consequent on the foregoing, you are invited to attend on the commission, and we say what the address is, and the date and time to be interviewed for the purpose of providing an explanation to the Director of Investigation or his designate for the purpose of answering questions concerning the investigation. And then the notice goes into the areas that will be covered. We provide attachments, so if there are things that need to be explained, those things are attached. For example, it could be a bank statements, it could be land title, whatever the case may be, whatever we need to be explained would be attached to the notice. The notice is dispatched in triplicate. One of the copies would be endorsed by the declarant as having been served on them, and that is returned to the commission. So that is how they are advised that they.
Can you release your mic, Mr.? Okay. So let me just be clear and follow the process. If I'm being investigated, Mr. Beresford would indicate to me that he's referring a matter to you, but he doesn't state the nature of it. You would then write to me to say a matter has been referred to you in relation to me, but at that stage you don't include the specific nature of your investigation. Once you have done your due diligence and weighed the evidence, and you have come to a conclusion that you should commence an investigation, you then write that what I would receive my third correspondence as a declarant then. The first from Mr. Beresford to say you have referred to you. The second from you to confirm that you are in receipt of a referral. And then the third, that having done your preliminary checks, you are now commencing this investigation and you are calling on me to answer these specific allegations or charges. Is that correct?
Correct in every respect, except to say that at that stage we are not commencing the investigation.
Well, not
We are
commencing.
continuing
You're
with the
continuing.
investigation, but we are at a stage where we are asking you to explain assets that we find to be disproportionate to your lawful earnings.
And the same principle would apply whether it's an investigation for another matter. So, for example, failure to declare particular assets, etc. The same principle in terms of the process applies, where Mr. Beresford indicates to the declarant that a matter has been referred to you, you acknowledge, and then once you get to a stage where you believe they're sufficient, then you write to the declarant. Is that correct?
Not in all cases.
Okay.
Because the illicit enrichment matters are peculiar, it requires that the declarant explain the source of funds for the assets. So it is not done in the very same way, but there may be a time during the course of the investigation that the declarant would be called in to answer questions, for example, under caution, after having collected the evidence and we are satisfied that there is sufficient there to arouse our suspicion that an offense has been committed. Then we would call them in at that stage. But each investigation, of course, will turn on their facts.
Relating to this, or oh, right. So I recognize a member Charles, and then Member Malou Fortes, in that order.
Well, I have some specific questions and comments, but not relating to this, but in relation to this particular, to follow up, the notice of which you explained a while ago um, falls within the context of section 53.3 of the Act still, correct? Let me assist you. Let me assist you. Um, I'm referring to the section, trying to pull it up. That appears to restrict public commentary on matters before they are tabled in the Parliament. Such a notice provided to anyone. If Julian Robinson, as a member of the Parliament, were to receive such a notice, um, as explained a while ago, regarding illicit enrichment, you, Director, would still expect that it would be treated within Section 53, subsection 3 of the Act, and that would not be then part of what would be public knowledge until it is tabled in Parliament.
Thank you very much, Chairman. Yes, indeed. The notice, having received the notice, the declarant is, or anybody else who comes into contact with the notice, should not breach Section 53 by announcing that there is an investigation. And you may refer to Section 56, that is even more restrictive than Section 53, that requires that all information in relation to complaints, statutory declaration, any matter before the commission be kept strictly secret and confidential by members of the commission, staff, as well as anybody who has an official function in relation to the Integrity Commission Act. I paraphrase, so you'd have to check the Section 56 for the wording.
No, I want to thank you for that clarification, because I think that a lot of individuals in our society perhaps had a misunderstanding of the parameters within which one ought to operate in those kind of matters, particularly the matter as raised by Member Robinson. So you say 53.3 is followed by Section 56 regarding the confidentiality of these matters prior to tabling. I have some other questions, Chairman, but I don't want to jump over. Mrs. Malou Ford had a. Before you go to the next,
I'm
Mrs.
seeing
Malou
that Member Malou Fortes is not quite ready.
I
So
just want to ensure that my other two questions are answered. The one related to the percentage of investigations that are referred to third parties and the rationale for that, and then in relation to um, the decision not to publish contracts and whether the Integrity Commission is open to independent legal advice on that particular provision, and to ask the specific provision in the Integrity Commission Act that the Integrity Commission has relied on to support its decision.
Thank you. Thank you, Chair. Thank you, Mr. Chairman, and committee members. We are happy to be here and to answer your questions. There is two matters I want to address. Member Chuck made a comment about reports being sent by the Director of Investigation to the Commission or to the Executive Director. The Executive Director has no substantive function when it comes to investigation reports. It's merely procedural. And the process is governed by Section 54.1 of the Integrity Commission Act, and I'll just read it. And it's important so that we can bring clarity to this thing, because I've also seen it on social media. The ED has absolutely no role to play when it comes to investigations. It says, on completion of an investigation, the Director of Investigation shall prepare and submit to the Commission, not to me, to the Commission, through the Executive Director, a report of his findings and recommendations. So it merely comes through me. And for clarity and for full understanding, we can tell you what the process is. The Director of Investigation sends me the report. It's password protected in case it gets somewhere, but it comes to me by electronic means. Once I receive it, literally within minutes, and this applies to all the reports I've gotten over the past nearly 5 years, I send it to all 5 commissioners by email. And then via another means, which I will not disclose, I send the password. And that's all I do. He sends to me, and I send to all the commissioners, and I copy him so that he knows that it has been sent to the commissioners. And he would have provided me with the password by another means, and I will send that password to the commissioners. That's all I do. And then once the commissioners decide, in keeping with section 54.4, that the report should be tabled into Parliament, they instruct me to proceed. And then the cover letters that you see, which accompany the investigation reports, I sign on behalf of the Commission. That's it. So, Member Chuck, I hope that clears it up. So it's not that it comes to me or the Commission. It's always going to the Commission, but through me. The third question that Member Robbins asked, I can address that. Member Robbins asked about the QCA reports. These are quarterly contract award reports. I had developed that concept back in 2006 when I was Contractor General. And the Office of the Contractor General during my tenure and subsequent to the end of my tenure under the stewardship of Mr. Dirk Harrison had continued to publish these on a quarterly basis. And I can tell you that up to now, in 2024, so it's 2006 to 2024, we're still getting the information from public sector agencies. And a report on that is actually the Director of Investigation, under whose portfolio that falls, still reports on it. Because remember, the Director of Investigation has assumed all the functions that the former Contractor General had. So public bodies, you'll be happy to hear, still provide that information on a routine basis, but we don't publish the database as we used to. And we stopped publishing it after we consulted among ourselves within the Commission as to whether or not the continuation of the publication of the database would violate Section 56. Now, Member Robinson, you said 53. 53 doesn't concern the QC, it's 56. And we hear references to the gag clause, which is 53.3, which speaks to a prohibition not to talk about investigations until report they're on a table in Parliament. But the thing about it, the irony about it, is that Section 56.1 is much wider in its purview than 53.3. If you didn't have 53.3 under 56.1, you couldn't do what 53.3 says you can't do. So it's 56. That's a relevant section, and I'll read it for you. Subject to section 42.3b, and 42.3b is a section which requires the Commission to publish the annual summary statutory declarations, or a summary of the statutory declarations of the Leader of the Opposition and the Prime Minister. So it says, subject to that, every person having an official duty under this act, which means all of us, commissioners and employees, or being employed or otherwise concerned in the administration of this act, hereinafter called a concerned person, shall regard and deal with as secret and confidential. Then it specifically addresses certain categories of items, and then it has a catch-all, or what lawyers will know as a est justem generis clause. It says, shall regard and deal with as secret and confidential all information, statutory declarations, government contracts, prescribed license, and all other matters relating to any matter before the Commission, except that no disclosure made by the Commission or other concerned persons in the proceedings for an offense under this Act or under the Perjury Act by virtue of Section 17.2 of that Act shall be deemed inconsistent with any duty imposed by this section. So in a nutshell, what it does is that it prohibits or it requires all employees of the commission and the commissioners to regard as secret and confidential any of the matters listed here, including government contracts or any other matter which is before the commission. Now, I've heard talk that a matter is only before the commission if, and it goes on, but it's very clear. It says any information dealing with statutory declarations, government contracts, license, or any other matter before the commission shall be treated as secret and confidential. And subsection 3 of that section makes it a criminal offense, punishable by fine or imprisonment for any of us to do that. Now, Chair, I agree with Member Robinson that this section is drafted much too wide. And perhaps it was not the intention of Parliament for it to capture so many things. And we have addressed that in our proposals for an amendment to the Act. And so we share your position on that. Because a lot of things about this provision runs contrary to Jamaica's treaty obligations on the United Nations Convention against Corruption and also the Inter-American Convention Against Corruption, which spawned our Corruption Prevention Act. And we have said that in our recommendations to Parliament, the Joint Select Committee and this committee, in terms of a proposal to have this amended, it's too wide. We understand that there must be a balance. You know, some things must be considered sensitive and confidential and kept that way. But this goes too far. And we have submitted that. So it now comes to the question as to, opinions. Now, as you go through this piece of legislation, as all of us had, and I've found innumerable instances of what you call conflicts of law. I lectured law for 10 years. And it's not unusual for pieces of legislation to have clear conflicts of law. And Mr. Chairman, this is perhaps one of the reasons why it's very important to have this process and the Joint Select Committee process, where we review the legislation to identify those possible conflicts, where you're looking at things that, this could never be. You pointed out one earlier, Section 6.3a, which says that the Commission shall not be subject to direction of any authority. And I gather that someone else on that side is saying something else. These are clear conflicts. Yes, same act. And so it's important that these things are brought to light. And the Parliament, through you and discussion with us, given an opportunity to review them and decide exactly what is it that Parliament wants, and then to amend the law. You're going to have conflicting interpretations. We've heard one, that sort of thing. But I think these are provisions which are ripe for consideration, and they are ripe for review and amendment, for Parliament to reflect actually what it is that they want. But as our chairman said, we believe in the rule of law, and we try to reflect that in our work. And as I said, we did not just get up one day and say that we're going to stop publishing the databases. That database has over, I think, $250,000 contract award entries, running into over $1 trillion. Someone pointed out on social media recently that the GoJEP site replaces that. It can't. Our database, they've been tracking contracts to award it from May 1, 2006. And that's almost 20 years. And it's freely searchable by any member of Parliament, any member of the public. No member of the public can just go on the GoJEP site and search for contracts. In any event, they won't find it going back to 2006. Only the Integrity Commission, having assumed the responsibilities and all the data and resources coming from the Office of the Contractor General, has that information in its repository. And it's very important. It's a great tool for transparency because it tells the taxpayer how their money is being spent. If public body A, you want to track all the contracts it has awarded since 2006 up to now to a particular contractor, you can get it like that, and it tells you everything. You can put in all sorts of permutations in your searches. So
So just a follow-up on this as, have all your questions been? All right, let's have that.
To the third question, Chairman, through you, uh, Member Robinson has asked for the percentage of cases that have been referred to external entities, as well as what is the rationale for um, referring matters or not. I just did a quick calculation over the 5 years period. It's just over 3% of, of cases that have been referred to external entities. Uh, when we are looking at cases generally, uh, and whether or not they should be referred, we have to be mindful of the remit of the commission. Although there are other entities with um, similar or complementary powers, we have to be careful not to divest the functions that we are to perform, particularly when you look at the independence of the commission in the treatment of matters having to do with public officials and whether other entities enjoy the same independence. Now, what we do and what you will see coming out of the investigation reports that have been tabled so far is the request for information from other entities, for example, competent authorities. You'll see, for example, requests for statements, information from the tax administration, etc. We also ask for information from the FID to assist with our investigations. There are also opportunities for joint investigations, and it depends. So far, the Commission has been invited to participate in joint investigations by other entities, and we are presently participating in at least one or two of those investigations. So the rationale around it is really the subject matter. What is the subject matter that is being investigated? Can we pass this on to another entity to investigate it, to be investigated, particularly if they do not have the remit to investigate that matter? And if you look at, for example, at statutory declaration related matters, who would we refer it to be investigated? For example, if you are looking at just purely the statutory declaration, then of course you'll have to refer to the functions of the commission to investigate these matters and whether that can be carried out by another entity. But as I've said, we've cooperated with other entities. We have from time to time meetings. We try to do them on a quarterly basis, particularly in recent times. We're trying to get back to our quarterly meetings with our competent authorities and other partners to ensure that we keep um, good relations so that we can share information where it is possible for those that are listed under Section 7 and for those that have not been listed to ensure that we work out a way where we can get information from those entities.
Okay, well,
Chairman.
we are going to continue the discussion. Bear in mind, of course, that we have to 12 o'clock today. Uh, well, I may then have to excuse myself, perhaps, and ask you to chair for any further leading up to 1 o'clock. But I do have uh, an obligation at midday. But suffice it to say that the comment made and the explanation given by the director, Christie, is apropos in relation to the work of another committee. And I sit in both capacity as I wear both hats, and I'm fully seized by that. And we are particularly seized by the seeming levels of contradiction within the act itself, two of which we raised just in this committee meeting here today. But there are several others, and the breadth and width of it, and what it does, even in instances of, you know, threatening to breach natural justice and various areas of, individual liberty and so on. So we need to take that deeper look, and I'm very happy that the discussions here have brought out even further the need for us to move faster, in fact, in dealing with these legislative amendments that the JSC is responsible for. So, and I can give you my assurance that we will be acting very expeditiously on these matters, starting the latter part of this month into the end of the year.
Chairman, I had a follow-up question to what was just said by Mr. Christie. He referred to Section 56 as being the relevant section, and in my understanding, relating to the constraints placed on members and officers working in the Integrity Commission. But as it relates to members of parliament, for instance, because we're speaking a lot about the parliamentarians, a member of parliament would be in breach of Section 56 or Section 53(3) if it is that they were under investigation and published that information. All right? Because we have clarified that members of parliament under investigation would be in breach of the confidentiality in this act if they spoke of it. But would it be relating to Section 53(3) or 56, in your opinion, Mr. Christie?
I'm sorry, just to indicate, members, that I do have an appointment with the non-resident ambassador for Rwanda to Jamaica. And he's passing through, and I did make it for 12 o'clock because we had hope for a 2-hour meeting. Yes, and so I will excuse myself to meet with him, and Member Chuck will assume the chair until my return. Proceed, Member.
I had asked a question, Chairman. Very important question for me to understand.
Yes, Chair. Member Charles, I think it's a fair question in the circumstances, given the language of both provisions, as to does it prohibit just members of the commission, employees of the commission, or does it extend to other persons? The commission actually issued a statement with respect to Section 53(3) the other day, when there were some reports from at least one media house about our investigation reports, which had not yet been tabled in Parliament. Not reports, one report. And the point that the commission made was this. It says, and this is what it highlighted. I'll read the entire section and tell you what we were highlighting. Onto the table in the Parliament of a report under Section 36, all matters on investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of investigation in this act. So it's or any other person.
Including members of parliament.
Well, what was Parliament's intention? Parliament wrote the law, or any other person.
So what I was asking, Mr. Christie, not to
Yes.
stop you, but I'm under constraint of time, and that's my follow-up to Member Robinson's question, but I haven't posed my question yet. So we are clear now. Members of parliament under investigation would be in breach of the confidentiality if they were to expose
That's not
it.
my response.
Okay, guide me.
not
What
my
is your
response.
response? What is your response? Guide
I
me.
told you my response. I simply said that we issued a statement which alludes to this phrase, or any other person. You can interpret it how
Okay,
you want.
so let me make it
Yeah.
clear. Members of the IC and any other person
That's what the law says.
ought not to speak of these matters until they are tabled.
That's what the
That's
law
what
says.
thank you for that
That's
clarity.
what
Now
the law
on to
says.
my question.
No, I don't think you're finished. You also asked the same question with respect to Section 56?
No, well, what I asked originally was whether you would find the constraint on a member of parliament within Section 56 or within Section 53(3). But you went on to provide commentary on a statement made by the IC around it, which was useful. But you haven't told me if it is that a member of parliament specifically would be constrained
Member,
while under
Member
investigation in
Charles, Member
56 or
Charles,
53.3.
Member Charles, you've asked a question and I provided my answer. All I'm telling you is that the law was written by Parliament, and I think Parliament is the appropriate
Your answer is
entity.
sufficient. No
What's-
problem.
what's
Answer
your-
is sufficient. But let me go on to my, because the clock, we're watching it. Chairman, I think that the matters before us today and the discussion and the report and issues relating to the Integrity Commission ought to receive more than the time that we have allocated to it. It is of great importance. But I want to say this. Thank you for the clarity in relation to any other person. That includes members of parliament. But let me go to what I see as an insightful and thought-provoking opening from our chairman of the Integrity Commission this morning, who it is an honor for me to be in the position to listen carefully to what the Honorable Justice Panton said. And he has made a statement to the nation, which is very clear and which causes me to have deep concern. It is evident the frustration expressed by the chair in relation to perhaps the perceptions around the Integrity Commission. And it is concerning to me of the impact that that might have in terms of the operations. Nevertheless, I want to join with Chairman Panton in his, one, highlighting that our Prime Minister has given full support to the Integrity Commission and acknowledging even the commentary of the Prime Minister in terms of how he views the Commission and how he views the importance of its objective. It's important to put that on note so that the public can know that that is the feeling of the Integrity Commission in relation to the Prime Minister's stance. Secondly, I want to acknowledge the strong rebuke of any statements that contribute negatively to how our society sees the Integrity Commission or sees even our engagement. And matter of fact, the specific words were such statements that fuel a sort of mood among sycophants and that focus on the society that we live in, and that we need to understand persons, we have to be careful of what we say. And in that context, even though this was not the intention when I stepped into the parliament this morning, but because of the statements, I'm compelled to ask of the Commission's perspective in that context on statements that have been made by the Executive Director in September 2023, when following the unfortunate incident on Director Evans, we heard a response saying, you should ask the government that, ask them what it means. I note the response in writing, the explanation, but I would like to know objectively, and this is not an attack. In this space, we should be able to have honest, open conversation, and the country wants to know this. So let us put it to rest today. What, Chairman Panton, is your perspective on those comments from our Executive Director following such a significant and unfortunate incident? Do you consider those statements to be statements that you would categorize as such that fuel a sort of mood among sycophants and statements within the category that we should be careful of because of how the society would view them? Chairman, I'm very interested in knowing that. And in that vein, I have other issues, but I will ask the chairman that first and then move to the other matter.
Yes, Chairman. Not really in an argumentative mood today. I'm in a very docile mood today. I'm surprised that that statement by the executive director has been raised again. The fact of the matter is that those of us who are on the commission were in a position then, at the time of the incident, to understand why the executive director reacted as he did. Now, there were some very serious security concerns. I don't want to go in depth, but I have to say, because I have been asked, that Commissioner Anderson, Commissioner of Police Anderson, gave certain instructions to one of his senior members, and those instructions were not carried out. Had those instructions been carried out, the incident may well not have happened in respect of Director Evans. And in fact, Mr. Chairman, as a result of the disregard of the instructions of Commissioner of Police Anderson, I had to write a letter to the Prime Minister of Jamaica, copied to the Minister of National Security, exactly 1 week before this incident. And there's much more I could say, but the reaction by the ED was, to our mind, understandable. I leave it at that. I'm not saying anything more on it, Mr. Chairman.
Yes. So, well, when the chairman speaks, I know for sure it is final. He is not speaking further on it. But, you know, Chairman Panton, I speak directly to you in saying, clearly, you know, I have no intention of being antagonistic to you. That would cause me to be scolded in other places. However, I am compelled to ask a question because we sit here not just in our own individual capacity, but we sit here representing the nation, a nation that has asked questions, and it may be best for me to pose them in this way because it gives an opportunity for the Integrity Commission to ventilate an issue, which is critical. The Integrity Commission is one of the most important institutions in our country. And we don't want a situation where you, Chair, or your commissioners feel in any way that the Parliament is attacking. And when I note your opening remarks, I note your reference to our psychologists perhaps assessing us and us needing to examine what we're digesting as it may be impacting us in particular in terms of how we operate. And that's not the kind of engagement that I believe the country would want between the IC and the park, nor is it the kind of perception that we want. So it is our responsibility to dispel that and to remedy it if it is that there are things that have been done or are being done to cause you to feel that way. You are an important element in terms of advancing transparency and accountability in our country. Chairman, a big part of that also requires us to look into the Integrity Commission itself. Because as I've said before, advancing integrity must require you to have integrity. And it must require you not just to have integrity, but for the country to have confidence in you being a person of integrity. And those perceptions are critical. And sometimes the reality and the perception does not meet. But we can't afford for that in these kind of circumstances. For instance, Chair, and I'd love to hear from Chairman Panton. Again, we speak about the society and the need for us to ensure that we are careful in how we operate. And from time to time, we hear comments about this matter that unfortunately occurred with Director Evans. And we even hear about the delay in responding to police officers. I don't know if it is true. I'd like to know as a member, because these are the things that are impacting the perceptions that the public have on the operations of the Integrity Commission. It could be not true, but I'd like to know, is it that there was a delay in signing the witness statements, a delay in responding to the police that has caused these perceptions to fuel? Because we cannot contend with an Integrity Commission that some members or too many members of the society, including members of parliament, do not have confidence in. You often hear, and I've heard before, commentary about Director Evans being a former advisor connected to political persons. Are these matters that the chairman and the commission have taken into consideration in terms of his operation? Are these matters that they have determined whether there is any impartiality or concern of impartiality or conflict? And if so, how have they operated? How have they dealt with those issues? I have no issue with director serving, but I would want to know, as a member of this committee and as a citizen of Jamaica, how have we addressed these issues that so many persons in our society talk about and that have crippled the perceptions around the Integrity Commission? Now, many people don't want to ask these questions because they are uncomfortable and it may cause discomfort. But my intention is not to be combative. I have no issue with Director Evans. I have no issue with Executive Director Christie. But I have a responsibility. And so I lay these things before us, not to be combative, but to be probing on behalf of the nation and to elicit a response that will cause me to be able to say to Jamaica, we can be confident that these matters have been deliberated, discussed, ventilated, and here's how our Integrity Commission is operating. And it's an important part of the discussion even around these reports, because all of it must be linked to the confidence reposed in the Integrity Commission by our people. It is the people that we serve. It is the people who are ultimately in charge. So, Chairman, again, let me just close off my remarks. I have other questions, but I want to close off this first one in just saying to Chairman Panton that I listened extremely carefully to the opening remarks. I listened even to his concern around the dispatch of matters from his office to the parliament, and the fact that some of those matters throughout that journey have been exposed before being tabled. And I wonder, even in this recent one, where I can be guided, where I think a member of parliament was actually able to make comments and address the matter before it was tabled. I share in the chairman's concern, but the question now for us is, what next? What do we do? What are we going to do to address those matters around the perception, statements made by executive corrector, the perception around the viability of a director in terms of his potential impartiality, and this repeated leaking of matters, whether it is from the IC or when the matter is moving from the IC to the parliament. These are problems that are impacting the credibility and the confidence that Jamaica can have in one of its most important institutions that our Prime Minister, as the chairman has said, has lauded, has supported with increased allocation, and continues to hold in that high regard.
May I answer?
Okay, just before you do, Chairman, I did indicate to you, and yes.
I want
and
to answer
should be
while you are
back.
present. I want to
I'll
answer.
be back
It
in
will be
15
short.
minutes because
It will be short. It is nonsense for this. It is nonsensical for there to be any discussion in respect of Director Evans. Director Evans went through a regular process for recruitment and employment and was appointed by the Governor General. Now, we need to bear in mind that Director Evans has nothing, absolutely nothing to do with reports. Nothing. His job is to go out there and inform people in respect of corruption. He has nothing to do with reports or prosecutions or non-prosecutions. And the fact of the matter is that we need to remember that our second, third, and fourth governors general were active politicians. So bear that in mind when people are talking about somebody having worked with a politician for a period. Our second, third, and fourth governors general were senior, active politicians for all their lives. And they served the country well. And this question of partisanship, we need to debunk it. And there is no question about the leak being attached to the commission unless you can prove it. Why wouldn't there be a leak while the thing is pending in the commission? And why is it as soon as it reaches Parliament, there's a leak? Think about that.
So with respect, I think the direction that this is going, yeah, and I believe that an answer is necessary. Yes, I do believe an answer is necessary, and I'll allow the member Charles to complete what he has to say in the presence of member Chuck in the chair, while I discharge this other duty and come right back to the meeting of this commission. So
Thank you, Chair. And let me, I took the opportunity when posing my questions before to reiterate that I have no intention of being antagonistic. And I really want to just reiterate that. Comfortable or cause discomfort is not because I'm trying to cause any argument with the Integrity Commission. It is because these are real live issues, whether we like it or not, that are surrounding us. They are consuming the discussions around the more pertinent things that we need to move towards in terms of transparency, accountability, and strengthening that framework in the country. So I say this with the hope that no one on that side will consider the questions in that way. And therefore, we could get some answers as opposed to comments, because answers might actually assist us, I think, in dispelling a lot of the rumors and issues that arise in the public domain. That said, we spoke of the rule of law, which guarantees independence from interference as well. And when I raised the issue, Chairman Panton, around the director's relation with a political individual, I raise it because of the comments that have been put in the public domain of the possibility of impartiality, and with the intention of not saying he's impartial, but asking the Integrity Commission what steps are taken to address these issues. That's why I raised it. Now, as it relates to the matters before us, I have one other question. I wanted to find out, and to interrogate rather, how the Commission views interim reports. Do we have such a thing? Maybe Director Stevenson is the proper person. I don't know. Chairman, you can decide who. But do we have such a thing as interim reports? And would interim reports ever be placed before this Parliament as tabled?
I'm trying. Huh? Turn the mic off for the moment.
Through you, Chair, presiding, to Member Charles, in the preparation of investigation reports and the conduct of investigations, I am only guided by Section 54. I do not see under this section a provision for interim reports.
So all the reports that have been tabled are final reports.
54, yes.
All right. Member Fort has not. Will you allow her to ask some questions before members Robinson, Poland? I am allowing you to. No, but they had their mics on before you. Well, he said that there's nothing as interim report, so everything is final report. That's the understanding I'm having from him. Is that so, Director?
Once the report is submitted under Section 54, Chairman, I believe it is a final report. Well, as far as I can see under the section, there is no such provision for interim report.
Yeah, so I just thank you, Chairman. You see, we can't afford for there to be any misinterpretation of what is said. So yeah, I think it is critical for us to be clear what the director is saying.
He's clear.
That anything put forward is a final report, and there is no room for interim reports.
Member Ford.
Tabled before the Parliament.
Thank you, Chairman. I join in welcoming the Commission and its staff to this sitting of the Oversight Committee. I have about 4 or 5 questions. I think the exchanges are helping us to gain clarity on a number of issues. My first question is directed to the chairman of the commission, Justice Panton, whether you are of the view that the independent exercise of statutory functions means that one is accountable to no one else.
First again.
No, I'm not of that view.
Thank you. The second question is whether you, on behalf of the commission, has ever refused or rejected an invitation to attend upon a meeting of the Integrity Commission Oversight Committee prior to today.
No.
Thank you. In your opening remarks, you chided that the commission takes orders from no one other than the court. Are you of the understanding, or what is your understanding of the nature of the IC's accountability to Parliament, having regard to sections 4, section 5, subsection 4, and section 6, subsection 3. Section 5(4) is a provision which states that the commission shall, subject to section 34, subsection 3, and section 36, subsection 4, be ultimately responsible and accountable to Parliament for all matters relating to the functions of the commission. The two provisos, 34(3), relate to the Director of Corruption Prosecutions not taking directions from anyone, and section 36(4) has to do with the exclusion of matters that may be prejudicial or which are subject to legal professional privilege. So I'll just restate the question. What is your understanding of the nature of the IC's accountability to Parliament, having regard to sections 5, subsection 4, and section 6, subsection 3 of the Integrity Commission Act?
My understanding is that the Integrity Commission cannot be ordered by anybody other than Parliament. That doesn't mean that it isn't accountable, because everybody is accountable in public life to at least the public.
You said to Parliament, I think you meant the court.
What's that?
You said cannot be ordered.
Cannot be ordered by anybody other than the court.
You said Parliament.
Well, that of course would have been a big slip. Because that would not happen.
My other question at this time?
I thought you said 3.
No, I didn't say 3. Or at least I don't recall saying 3.
You don't recall? Yes, Madam Minister.
Has the Commission examined the practices and procedures of any public body?
Before you, could I just to, a number of students are here and I know they're leaving shortly, but I want to say to the students, if you don't mind, I just want to thank the students of attending Parliament. They're from the St. James Prep, 44 students and 10 teachers. You have been sitting there silently. I hope you enjoyed the session so far and continue to have a very good day. Okay, it's okay. You don't have to clap. You can go now. All right. Okay.
Has the Commission examined the practices and procedures of any public body with a view to making recommendations to the Parliament in relation to the revision of those practices and procedures? Directing attention to the function of the Commission set out at Section 6(1)(d) of the Act.
The Director of Corruption Prevention may be the one to answer that.
Miss,
The one who his name keeps popping up just because of his previous work history. Director Evans.
who is that? Go ahead. Sorry. Go ahead.
Good morning. Well, it's now afternoon. Chairman, members. So in terms of the work of the Corruption Prevention Division, actually substantive elements of Section 6 speaks to the work of the Commission, of the division, in terms of preventing corruption. We've spent a lot of time over the last 3.5 years since the division was formed on public education. We've spent a lot of time on developing a national anti-corruption strategy. And we have also done a lot of work in terms of stakeholder engagement. And in fact, on our website, we actually list on a quarterly basis the interventions that the division would have done over the last 3.5 years in terms of public education, in terms of stakeholder engagement, participation in conferences, workshops, etc., stakeholder engagement, etc. And we have done substantive work in that regard. In respect of Section 6(1)(d), which speaks to the practices and processes of public bodies, that is an area that the division we have developed a concept as to how we intend to do that. And the idea is that it wouldn't be punitive. So the idea is that we want to, and we have developed a risk template, and we intend to go into public bodies and say, we plan to do a survey first as a first step to say what are some of the practices that you currently have in vis-a-vis corporate governance architecture. Do you have, for example, an audit committee, a procurement committee, an IHR committee, for example, amongst other questions? Once they respond to us, we will then, using other indicators, develop a risk profile of the organization, whether low risk, it's a low risk, it's a medium risk, or a high risk. We will then assimilate that data, interrogate that data, and make recommendations to the public body as to areas to improve the architecture. In addition to that, the investigation division does, in fact, in its reports, makes active recommendations vis-a-vis risk assessment of public bodies. So as a division, we haven't formally started the process yet. Again, the division it's a young division, 3.5 years, and we have spent a lot of focus on other areas, but we do intend to advance this particular area in this fiscal year. And I can assure you of that, member.
Thank you. I have another question at this time.
Sure.
In the investigation of complaints and the review of statutory declarations, is the Commission of the view that it has the power to pierce the corporate veil without an order of the court?
In fact, right. Yes, I'm doing so.
So for members of the public who may be listening and watching, in law, a company is regarded as a separate legal person. And there are specific principles of law in relation to how a company is treated vis-a-vis its shareholders and its directors. And I'm just seeking an understanding of how the Commission carries out its functions. So I will repeat, whether the Commission in investigating complaints or in its review of statutory declarations is of the view that it has the power to pierce the corporate veil without an order of the court.
As a collateral question to that, can declarants or should declarants be asked about the assets and liabilities of limited liability companies of which the declarant or the member of parliament or public official is a member? On what basis do you do so, which is ancillary to that question of piercing the corporate veil?
Chairman presiding, through you to Member Malahoo Fort. Before proceeding to answer your question, though, I am constrained in saying that there are certain matters before the court, and a part of the application deals with the issue of the corporate veil, and I would be very responsible to go down that road at this time, except to say that insofar as we have operated, we believe that we are complying with the law as it is.
My question does not relate to any particular case. My question is a general question in respect of the approach taken. So it's not in respect of any particular case. Those who have spoken have been at pain to reference the law, even offering a view that some provisions of the law may be in conflict. But we're talking about principles of law and an understanding and an approach that is taken.
I still, Member Fort, have to be cautious in how I approach that question, because anything that is
It's a simple
decided,
yes or no, you know.
I cannot answer in that way, except to say that insofar as we have conducted investigations based on the circumstances of each case, we believe that we have complied with the law. But in terms of that particular question, I think it's a matter that has to now be decided by the duly constituted tribunal, and I would not attempt in any way to assist the tribunal or to influence it in any way by answering, even generally, because of course the law, as you know, would be of general application.
You are not an attorney at law by profession, Mr. Stevens, are you? You are? Oh, I'm so sorry. Yes.
Well, I hope it is not because I have not acquitted myself well
No,
by
not at all.
answering that question.
But,
Not at all. Just one other question.
no,
at
but I
this
mean,
juncture.
the ancillary question, Director Stevens, is it relevant to be asked in declarants about the assets and liabilities of limited liability companies? Not the declarant's interest, but the assets and liabilities of limited liability companies.
Mr. Chairman, the ancillary question, as you term it, it still goes to the heart of the particular question that Member Ford asked. And so if I answer that, I would really be answering the question that Member Malahoo Ford asked. And in respect to the court, I cannot answer that question at this time, but I am sure that in due course, the court will return its ruling in the matter, and we will have the clarity around it.
I have another question. When the commission requests information of financial institutions about the accounts of declarants, as you have done in review of statutory declarations, do you inform the declarants that you are seeking information from the financial institution in respect of their accounts, having regard to the laws around banking secrecy?
Insofar as my functions are concerned, I do not inform the declarant that I am requesting information about their accounts, and I believe that I am covered by Section 48 of the Integrity Commission Act, which speaks to the secrecy provisions and other laws of a similar nature, for example, the Banking Act. So I go under that provision to ask questions. Now, as a matter of investigative strategy, in most instances, it would be foolhardy to inform a declarant. Section 48, I believe it's about 48.4. I could check. It should be about 48.4, but you can always check, and I will come back to it. But it perhaps would be foolhardy. Okay. All right. Thank you.
You want to go first? Then?
Sorry.
Chairman,
Yeah, okay,
I-
Member Robinson.
I'm referencing the annual report of 23-24 and the chairman's opening remarks, the second page, paragraph 8. And I would like clarity on this particular matter.
This is the 23 report.
23-24 report, the chairman's
What page?
page 2 of the chairman's opening remarks, the end of page 2. If for the 272 is page 8 of the 272 pages, and it's at the bottom. And I'm going to quote the last sentence written by the chairman, and from my interpretation, there appears to be a bit of a contradiction. And I quote, "Of course, there is nothing to prevent declarants or persons under investigation from speaking on the situation as it relates to them." So I am seeking clarity. If an declarant is under investigation before the report has been tabled in the parliament, is it against the law for the declarant to acknowledge that he or she is the subject of an investigation?
In my opinion, a declarant can always speak about his or her situation at any time. That is my view of the law.
But it sounds inconsistent with
Well,
what Mr. Christie said.
the section says nobody is to speak about the thing, but I can't see why I am involved in a situation and I cannot speak about it. That is my interpretation of the law. It
Yes.
doesn't follow, although I think I'm right, it doesn't follow that I'm right.
I'm going to ask the chairman, is your interpretation of the law consistent with the Integrity Commission's interpretation of the law on this particular matter?
What's the question?
If the chairman's interpretation of the law, as written here on page 2 of his opening remarks, if it is consistent with the Integrity Commission's interpretation of the law on this particular matter. It's a very important matter because there have been public comments made that no individual can speak on a matter until it's tabled, even if you are the subject of an investigation. But the chairman...
No, I don't share that view.
Right, but is that
I
the view
share
of
the
the
view that the commission and other people should not be speaking about matters as forbidden by the legislation. However, in my view, and as I say, it's my view, that a declarant can speak about himself. I don't see anything to prevent that.
All right.
That is my view.
All right. Thank you, Chairman.
It's following this question, not a separate question. So
Do you mind?
it would
Go
be
ahead,
logical.
Member Chance.
Just, since I am the one who had raised it earlier, it is perhaps important for me to gain clarity because I am now not clear. Section 53(3), and let me read it. Until the tabling in Parliament of a report under Section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential. And no report or public statement shall be made by the Commission or any other person in relation to the conduct of this investigation. Now, I read the chairman's remarks, and I too noted the sentence that said, of course, there's nothing to prevent declarants or persons under investigation from speaking on the situation as it relates to them. You can't tie somebody out. They can say what they want to say. But the real question is not whether they can say it. You can't stop me from saying what I'm saying right now. But if I say it, am I in breach of the confidentiality and the constraint that is affected by this section? That is what Jamaica needs to understand. Not whether somebody can talk, mouth make for talk. But if you talk, are you contravening this section? That is what the country needs to understand from the Integrity Commission.
Chairman, I'd just like to just respond to what was just said. This law was not written by the Integrity Commission. It was written by the Parliament of Jamaica. And if there are flaws in the law which are creating different interpretations, I think that's a matter for the Parliament. That hat can't be placed on the Integrity Commission's head. It can't. We have already addressed the issue of conflicting interpretations. It is the responsibility of the country's lawmakers to make clear laws. And if we get into a situation, a pit, where we're, jumping over ourselves as to what this means and what that means, that's a matter for the Parliament to deal with. It can't be our responsibility.
No, 1 second.
It is a conversation that,
No, 1
Chairman,
second.
hold on. No, it cannot be that I ask a question, there's a response, and then we're going to move on. I would like an opportunity for the floor for me to respond. Now, Mr. Chairman, this is the second time that the Executive Director has responded to my question or comment in that way. He has made it clear now that the hat shouldn't be on his head in interpreting the law. Now, if the Executive Director of the Integrity Commission ought not to be called upon to interpret the law which is going to direct his function, who should? It is not only inappropriate, but I believe that response speaks to the stance of the Executive Director. And if I ask a question, you can respond properly in giving me your opinion. You see how the chairman responded? That's what I'm talking about. The chairman gave us his opinion and said, I may not be right. The chairman wouldn't look on me and tell us that is for you to deal with. I think that response, the Executive Director, is not in keeping with the tenor of this Oversight Committee and the conversation we're having now. I'm asking again, and hopefully you will be minded to actually give me some insight into how you think, because how you think and what operates in your mind as the Executive Director is critical to my understanding of the operation of the Integrity Commission and the confidence I repose in it. So if you're unable to answer the question, then you tell me you're unable to answer it because you don't know what it means. But I don't think so. You are someone who has taught law. You are a respected attorney at law. You have served more than once in this position. Your opinion is critical. It is significant. So let me ask again.
Member, just before, there's a member who seeks an intervention for a point of information. And
To
please,
seek intervention in my questioning?
yes, That's what he says.
Chairman, I just want to note that I was a member of this parliament when this law was passed. And I clearly recall what the intention was. It is to guard against people who are being investigated, being prejudiced. That person can waive whatever protection that he or she might have under the law. It is to ensure that investigations are done in secret so that the person who is being investigated can have that secrecy preserved. But that person can waive that secrecy anytime by saying, I am being investigated and here are the facts. And I don't see anything wrong with that in terms of the general
Chairman,
provision of confidentiality.
can I just say that the comment from Member Paulwell is irrelevant as a point of order. It has no bearing on the question that I'm posing. He will have an opportunity to speak. Can I finish?
I accept what you say in your...
Listen.
In all
Chair-
fairness, I accept what you've said, but his right to intervene is to be respected.
I respect
So,
it, but
I
I'm
take your
commenting
point
on his
in
right.
terms of your own interpretation.
And yes, I have
of
a
his
right. I have a
intervention.
right
Not-
to
not a
respond.
problem with that, of course.
And in the middle of my
So can you
questioning,
please finish? Yes,
you ought not to obstruct it. We're all members here. And I get the impression, Chairman, this is a serious matter, And no, but why I'm saying this, you have Jamaicans right now listening to us who are confused. So when I ask a question, it is not to attack anybody. I'm not sent here to be friendly. I'm sent here to be effective. And the question, and this is it. Even me asking this, Member Paulwell is saying you're being defensive or offensive. I'm not being offensive. What I'm being is probing. And maybe because of my legal training, it is not meant in any personal way. I am probing a matter. And I draw the comparison in how our chairman responded, expressing his own perspective and respectfully saying that he could be wrong. And I can respect that kind of response. But I don't accept that as a member of this committee, I can ask a question and it be said, you who wear the hat, not me. That couldn't be acceptable, Chairman. But let me ask again, for clarity. I raised an issue before around section 53 and 56 asking for clarity whether members of parliament who are under investigation are within the constraint of the Integrity Commission Act in speaking about such investigation before those matters have been tabled in Parliament. The response from the Executive Director to me was to read out a comment or a statement rather from the Integrity Commission that says, in my words, all officers or any other person fall within the constraint of the law, and in my terms ought not to be talking about the matter, whether you are in the IC or any other person. I even went on to ask specifically, members of parliament, the response are members of parliament persons. Yes. So that was very clear to me. Now, further to that, we have highlighted a statement, a sentence in the chairman's report that speaks to, of course, there's nothing to prevent declarants or persons under investigation from speaking. My interpretation of that is that you can't time them out. I can say what I want to say, just as I'm saying it right now. But that is not what I think is a relevant question for the nation that is watching us. The relevant question must be not can somebody talk, but if they speak, are they in contravention of this legislation? Now, for me to pose that question, it's important to answer it. So let me do it again and ask whoever wants to answer. Not can somebody talk, but if they do, are they in contravention of the Integrity Commission Act in its current state?
Chairman, through you, sir. I think before you left, I think what this further discourse has demonstrated, and this has been my posture. Yeah, thanks. I think this interchange and engagement, what is useful about it is that we're all talking about a piece of legislation which, interestingly, is on a review by this very parliament. And if we read the law, what the law actually anticipates is that after 5 years, observing how the law operates in relation to the commission, is there anything which needs changing? Now, it should not come as a surprise to anyone that there are going to be conflicting interpretations insofar as some provisions of the legislation are concerned. And to me, I don't see why that should cause any level of consternation. I think where we are right now is that we have identified a number of provisions which are capable of more than one meaning. They are equivocal in meaning. And you want to get to a point where you are clear, you're unequivocal in meaning. And I don't think we should be seeking to pin anyone on a particular interpretation A or interpretation B. When we look at the rules of interpretation, legislative interpretation, one rule that you look for, well, there's a literal rule, and I think that's what we're talking about. It says any other person. And the member is right, we are all persons. But there's also another rule. What was the mischief that the provision was intended to cure or to deal with? Was the mischief that was intended to deal with is members of the commission speaking about the matter while it's on investigation, or as the chairman says, was it intended also to extend as far as to the person who is the subject of the matter? Is he too prohibited from speaking? It stands to reason that the chairman is correct in his assessment in terms of what makes sense. What was the purpose of the provision? The member across the floor, he is hanging his hat on any other person. And that's what I read out. And I read it out in the sense that this is what the law states. Now, what do you, the lawmaker, mean by that? And yes, sir, there are members of the public who are listening, and they are confused. And I think right here, it is for us to get rid of that confusion. So I'll just say this, and I've said it before, and I'll say no more. We have identified another provision which is not unequivocal in meaning. And Chair, with respect, this is another matter that I think should go to the Joint Select Committee of Parliament, if you should so determine. And again, I repeat, it's our lawmakers who make the law. They're not infallible. And this is why we have processes like this, review processes. We're not infallible either. And as I say, this process serves good reason, a good public purpose, to identify errors. It may not have been Parliament's intent to say it this way. Madam Malhu Ford pointed out that, despite Section 6.3a of the Act, which says that the Commission shall not be directed by any person or authority, Parliament is an authority. This committee is an authority. And the words are very explicit. They are unequivocally clear. But yet in another provision of the Act, it says that you're accountable. And there's no one on this side who would say that we're not accountable. I've said it several times in this chamber that we hold ourselves accountable. And we come here to answer your questions and to work with the committee as best as we can. So, Chair, I'll rest it, and I hope the member understands my position. I'm not here to answer questions in a way that satisfies anyone. That's not me. I will give you my answer to a question as I see it. We have identified another provision in the Interior Commission Act which requires address, and I leave it at that.
Chairman.
Except I just wish to point out that the explanation that you give raises a lot of questions about just how we have operated and functioned, referencing the law and the issue of the interpretation that we may have on the one hand, and the interpretation that the other, particular declarants might have on the other hand. What concerns me at this moment is the actual point you made, E.D. Christie, that the law has to be amended and dealt with dispatch. And I made the comment earlier as chairman of another responsible body that has that overall responsibility, that it will be done, and it will be done with dispatch. Because much of the concerns that are being raised here, the confusion that the member Charles is references, emanates from, again, the imprecise nature of the legal provisions. And the second element that I believe needs to be looked at is the absence of empirical data points for determination of decisions. So that there is probably too much that is left to the interpretation of functionaries in arriving at decisions. So one of the things that we have to look at are there possible parameters to be established, action points to be determined. In other words, a more empirical basis on determining what is required for certification, for example. And so that if we have a list of 1 item, 2 items, 3 items, 4 items, and all those items are met, then certification is automatic. And it removes the individual situation where a director of any area has the discretion to determine. And it removes the reference to phrases like, in his opinion, or if he's satisfied, that there's a system that everyone understands, both the declarant and the commission, as to what constitutes the satisfaction level. And once that threshold is reached, there's no question about certification. So these are points that we have to look at down the road, and definitely is part of the consideration that the JSC is seized with as we move forward.
Chairman. No, but there's some things have been said that I would like to quickly respond.
But in all fairness, you know, we cannot continue. Yes, right. So please, it's now, as we say, 12:51. Yes. And I want to make the point that I'm fully seized of how important this particular meeting is, and particularly that this is a historic meeting. It's the first time we're having the full commission before us. And it's only that we're going to have more of this. And I will sincerely hope that, you know, we can, after this meeting, structure another to continue perhaps elements of this discussion that are left undealt with. So I will continue, but bear in mind, Parliament must be ready for preparation at 1 o'clock. There's absolutely no getting away from it, because we begin at 2 in the next session. So Member Charles, kindly wrap up, and then we have quickly from Member Malahou Ford, and then
It is telling what has been said around this provision. In my reading, I recall, Chairman, hearing about strategic ambiguity, where persons can see something that is clear as unclear in order to foster debate, or what some call selective interpretation, where a clear statement or law can be seen as unclear if it doesn't align with the objective you seek. Now, I want to draw a distinction between one's aspiration and the reality. The law as it is now is the reality. What you want the law to be is an aspiration. And what I'm asking about is not your desire or aspiration, it is the reality of what is as it is right now. Now, the country, as said, is listening. And we have spoken about a number of things. The reference, Chairman, to Section 53 as a law that is unclear must be probed further. I would like to understand what word, what part, what element of that is unclear. And let me read it so that the country can hear it. Section 53.3. Until the tabling in Parliament of a report under Section 36, all matters under investigation by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no NO report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of an investigation under this Act. I would like to understand two things. What part of that you don't understand? What's unclear? And secondly, when I first raised it, the response from the executive director was to reiterate, it says any other person. So this member, who he says is hanging his hat on the words any other person,